Ready? Start. This is an appeal from an order of a single judge of the High Court of Judicature at Madras issuing a writ of prohibition restraining the Election Commission, a statutory authority constituted by the President and having its offices permanently located at New Delhi, from enquiring into the alleged disqualification of the respondent for membership of the Madras Legislative Assembly. Stop para. The respondent was convicted by the Sessions Judge of East Godavari and sentenced to a term of 7 years rigorous imprisonment in 1942, and he was released on the occasion of the celebration of the Independence Day on 15th August 1947. Stop. In June 1952, there was to be a by-election to a reserved seat in the Kakinada constituency of the Madras Legislative Assembly, and the respondent, desiring to offer himself as a candidate but finding himself disqualified under section 7(b) of the Representation of the People Act 1951, as 5 years had not elapsed from his release, applied to the Commission on 2nd April 1952 for exemption so as to enable him to contest the election. Stop. No reply to the application having been received till 5th May 1952, the last day for filing nominations. The respondent filed his nomination on that day, but no exception was taken to it either by the returning officer or any other candidate at the security of the nomination papers. Stop. The election was held on 14th June 1952, and the respondent who secured the largest number of votes was declared elected on 16th June 1952. Stop. The result of the election was published in the Fort St. George Gazette Extraordinary on 19th June 1952, and the respondent took his seat as a member of the Assembly on 27th June 1952. Stop. Meanwhile, the Commission rejected the respondent's application for exemption and communicated such rejection to the respondents by its letter dated 13th May 1952, which, however, was not received by him. Stop. On 3rd July 1952, the Speaker of the Assembly read out to the House a communication received from the Commission, bringing to his notice for such action as he may think fit to take the fact that the respondent's application for exemption had been rejected. Stop. A question as to respondent's disqualification having thus been raised, the Speaker referred the question of the Governor of Madras, who forwarded the case to the Commission for its opinion as required by Article 192 of the Constitution. Stop. The respondent having thereupon challenged the competency of the reference and the action taken thereon by the Governor, the Commission notified the respondent that his case would be heard on 21st August 1952. Stop. Accordingly, the Chief Election Commissioner (start), who was the sole member of the Commission for the time being (close), went down to Madras and heard the respondent's counsel and the Advocate General of Madras on 21st August 1952, when it was agreed that in case the petitioner's counsel desired to put forward any further representations or arguments, the same should be sent in writing so as to reach the Commission in Delhi by 28th August 1952, and the Commission should take them into consideration before giving its opinion to the Governor. Stop para. On the same day, 21st August 1952, the respondent applied to the High Court under Article 226 of the Constitution, contending that Article 192 of the Constitution was applicable only where a member becomes subject to a disqualification after he was elected, but not where as here the disqualification arose long before the election, in which case the only remedy was to challenge the validity of the election before an election tribunal stopped. He accordingly prayed for the issue of a writ of mandamus or of prohibition, directing the Commission to forbear from proceeding with the reference made by the Governor of Madras, who was not, however, made a party to the proceeding, stop. On receipt of the rule nisi issued by the High Court, the Commission demurred to the jurisdiction of the court to issue the writs asked for, on the ground that the Commission was not within the territory in relation to which the High Court exercised jurisdiction, stop. A further objection to the maintainability of the application was also raised to the effect that the action of the Governor in seeking, stop.